Andarki Shubhodayam. Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukar. ఈ వీడియోలో ముఖ్యమైన అంశం ఏంటంటే వెదర్ preliminary enquiry is necessary to register a case under Prevention of Corruption Act 1988. So దీంట్లో preliminary enquiry, normally in 99% of the cases, preliminary enquiry will be conducted, particularly in disproportionate asset cases. Sometimes, when the raid is necessary, when somebody is about to take the so-called bribery, definitely they have to conduct the raid. They need not go for the so-called preliminary inquiry. So, Supreme Court, in the case of State of Karnataka versus T.N.Sudhakar Reddy, is a retired Deputy Executive Engineer in Karnataka Power Transmission Corporation Limited. Criminal Appeal number 5001 by 2024, decided on 17 February 2025, wherein two judges bench, Justice Deepankar Datta and Sandeep Mehta, held that preliminary inquiry is not mandatory. Preliminary inquiry is not mandatory in corruption cases. Right. Why? We are going to explain. If you know the facts of the case, it is better. So, let us understand. This man, Mr. Sudhakar Reddy, he joined as Assistant Executive Engineer in Karnataka Power Transmission. So, transmission and generation, Genco and Transco, previously we used to call, now they are called SPDCL like that. So, Karnataka Power Transport Corporation Company Limited. Right? So, actually there are allegations against him that he has amassed wealth disproportionate to his known sources of income, and it will be around 3,81,40,246. That is the assessment. Right? So they registered a case in crime number 56 by 2003 under section 13(1)(b) of Prevention of Corruption Act. They added section 12 also. So 1988 case. You know, in the Karnataka state, the Lok Ayukta have got umpteen powers. They have got a power to register FIR. They have got a power. Of course, Edurappa case, you know very well, they are omnipowerful. So, for quashment of the proceedings against Mr. Sudhakar Reddy, they have approached the Karnataka High Court, which did not do ultimately, which quashed the appeal. Sudhakar Reddy approached the High Court of Karnataka for quashment, stating that preliminary inquiry is not conducted. So, therefore, basing on the averments or basing on the submissions made by the state of the Sudhakar Reddy's advocate, High Court is satisfied there is no preliminary inquiry, so therefore FIR quash. Against the quashment, the state of Karnataka, that is KP Transmission Corporation Limited, they have gone in appeal to the Supreme Court. Now, the key issue is whether preliminary inquiry is essential or whether it is sine qua non, essential or sine qua non in corruption cases. Please remember, actually here the case law cited by Mr. Sudhakar Reddy is very, very important, and normally day in and day out we will be coming across such cases. That is Lalit Kumari versus State or Secretary Home of the State of Uttar Pradesh. 2014 judgment. No doubt, in that case, the Honorable Supreme Court of India held that in corruption cases, preliminary inquiry may be done. When you are not sure about the amassing of wealth, when there is any exaggeration or bloating of figures, then you can conduct a preliminary inquiry. Preliminary inquiry may be conducted in corruption cases, maybe in misappropriation cases, maybe in SC/ST cases, maybe in family disputes like that. Lalit Kumari judgment clearly says. But here, It's not mandatory interpretation. Supreme Court is there to interpret the law. So Supreme Court clearly stated that. No doubt, but Lalit Kumari case says that they can do some preliminary inquiry in the cases of corruption, but still, where it is palpably clear, there is no necessity. It is only may be done. That is very, very important. Of course, the judgment is misconceived nation as corruption. The topic difference or preliminary inquiry depends on different circumstances. May be done, may be made and should be made and ekkada live. So, Justice Sandeep Mehta, who authored the judgment, he relied on the judgment Central Bureau of Investigation, that is CBI, versus Tommandru Hanna Vijayalakshmi. Tommandru Hanna Vijayalakshmi, 2021, I believe. So, judgment, which says, please remember, the accused cannot claim preliminary inquiry as a matter of right. So, baseline is whenever any cognizable offense is reported to the police, maybe local police, maybe CBI, they can register a case. Nobody can stop them. So, please remember, preliminary inquiry is not a prerequisite for registering a case against any public servant. So, therefore, the appeal is allowed and the FIR, which is quashed, that is 56/2003, which is quashed by High Court, is restored. Now he has to face the wrath of the trial of the court. Sudhakar Reddy. With this, I am concluding. Thank you very much.